The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom.
Things are heating up in Washington, D.C. Whether Trump tried to overturn the 2020 election or not, the debate has been going on since forever. Earlier reports said that former Justice Department Special Counsel Jack Smith told lawmakers in a private session on December 17th that his investigative team had gathered evidence beyond a reasonable doubt, showing that President Donald Trump had criminally conspired to overturn the 2020 election results. Now, the House Judiciary Committee, led by Republicans, chose New Year's Eve to make the transcript and video of Smith's testimony public, in which he justified his decision to oversee 2 criminal probes into Donald Trump that have since been closed. The House Judiciary Committee released a 255-page transcript detailing former special counsel Jack Smith's testimony. It includes questions from lawmakers and Smith's robust defense of prosecuting Donald Trump over retaining classified documents after leaving office, and alleged efforts to overturn the 2020 election. Trump pleaded not guilty, and both cases ended after his re-election. The release also includes video from Smith's nearly 8-hour closed-door deposition. In his opening statement, Smith told lawmakers that the decision to charge Donald Trump was his alone and was based solely on Trump's actions. He said the investigation launched under President Biden found evidence beyond a reasonable doubt that Trump pursued a criminal effort to overturn the 2020 election, and that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom.
Thank you for the opportunity to discuss my work as special counsel. I was taught as a young prosecutor to follow the facts and the law, and to do so without fear or favor, to do the right thing the right way for the right reasons. For nearly 3 decades, I've been a career prosecutor. I've served during both Republican and Democratic administrations, and I've been guided by those principles in every role I've held. I continued to honor those principles when I was appointed to serve as special counsel in November of 2022. The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom. He then repeatedly tried to obstruct justice to conceal his continued retention of those documents. I remain grateful for the counsel, judgment, and advice of my team as I executed my responsibilities. I am both saddened and angered that President Trump has sought revenge against career prosecutors FBI agents and support staff simply for doing their jobs and for having worked on those cases. These dedicated public servants are the best of us, and they have been wrongly vilified and improperly dismissed from their jobs. I made my decisions in the investigation without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 presidential election. We took our actions based on the facts and the law, the very lessons I learned early in my career as a prosecutor. We followed Justice Department policies and observed legal requirements. The timing and speed of our work reflects the strength of the evidence and our confidence that we would have secured convictions at trial. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Republican or a Democrat. Recent narratives about my team's work are false and misleading, including stories about our collection of toll records. Toll records were sought for historical telephone routing information, collected after calls had taken place, identifying the incoming and outgoing call numbers, the time of the calls and their duration. Toll records do not include the content of calls. Those records were lawfully subpoenaed and were relevant to complete a comprehensive investigation. January 6th was an attack on the structure of our democracy in which over 140 heroic law enforcement officers were assaulted. Over 160 individuals later pled guilty to assaulting police that day. Exploiting that violence, President Trump and his associates tried to call members of Congress in furtherance of their criminal scheme, urging them to further delay certification of the 2020 election. I did not choose those members. President Trump did. I hope that my testimony today serves to correct these mischaracterizations about my work, and to that end, I welcome your questions.
Just before Jack Smith's closed-door testimony on December 17th, the Justice Department emailed his lawyers, barring him from discussing the classified documents case, according to the 255-page transcript released by the Judiciary Committee, along with video footage. As a result, Smith could not answer most questions on that matter. The deposition, meant to examine claims of DOJ bias against Trump, focused mainly on the 2020 election case instead. Smith's lawyer also said the DOJ declined to send an attorney to guide him on what he was allowed to say. Trump repeatedly rejected the accusations in both historic felony cases against him, calling them a witch hunt. Smith, who was often attacked by Trump on social media and on various occasions, later dropped the cases after Trump's re-election, saying the Constitution bars the prosecution of a sitting president.
To ending the weaponization of government, to holding those accountable who'd participated in the weaponization of government.
Hold it. This is a good one. Is everybody listening? Deranged Jack Smith. We're going to call it the Deranged Jack Smith signing or bill. Go ahead.
One law firm that provided pro bono legal services to the special counsel's office under Jack Smith's leadership was Covington and Burling. As a result of those actions, we're now going to be suspending and putting under review the security clearances for the attorneys and employees at that firm who worked with Jack Smith's team. And we're going to continue holding the people who were responsible for the weaponization of government and who supported it accountable for what they did.
And you'll be doing this with other firms as time goes by, right?
We're looking at sort of the whole panoply of options.
The weaponization of our system by law firms, even pro bono work they're doing just in order to clog up government, stop government. And nobody knows about it more than me. And hopefully that'll never happen again.
So the Covington and Burlington?
Covington and Burlington.
Mr. President, may I ask you a question about Europe? So long term, do you plan to maintain the number of U.S. troops?
Wait, I just want to savor this one, please. Who would like this pen? Hey, why don't you send it to Jack Smith? A deranged person.
So, what do you say to people who worry that targeting an individual firm or individuals who aren't Jack Smith for his actions?
I've been targeted for 4 years. longer than that.
Thank you, sir.
So you don't tell me about targeting. I was the target of corrupt politicians for 4 years, and then 4 years after that. So don't talk to me about targeting.
During his deposition, Smith repeated his claim that Trump led a criminal effort to overturn the 2020 election and block the lawful transfer of power. He said the evidence showed Trump caused and exploited the January 6th Capitol violence, and that it was foreseeable. Smith argued Trump's false election claims were not protected speech because they targeted a government process, citing a tweet that endangered Vice President Pence. He said the case relied heavily on Republican witnesses who put country over party, including electors and state leaders. Smith said potential co-conspirator charges were still under review when Trump was re-elected and the office shut down. He also said Trump directed allies to call senators on January 6 to delay certification and defended subpoenas and phone record seizures as standard, noting Trump may seek retaliation against him.
What every prosecutor is practically required to do is to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain. Would you agree with that?
Yes.
If a prosecutor is obliged to choose his cases, it follows that he can choose his defendants. Therein is the most dangerous power of the prosecutor, that he will pick people he thinks he should get, rather than pick cases that need to be prosecuted. With the law books filled with a great assortment of crimes, a prosecutor stands a fair chance of finding at least a technical violation of some act on the part of almost anyone. In such a case, it's not a question of discovering the commission of a crime and then looking for the man who committed it. It is a question of picking the man and then searching the law books or putting investigators to work to pin some offenses on him. Do you agree with that?
I do, I think, yes.
Okay. It is here that law enforcement becomes personal, and the real crime becomes that of being unpopular with the predominant or governing group, being attached to the wrong political views, or being personally obnoxious to or in the way of the prosecutor himself. Do you agree that is a concern?
These are principles, and I agree with these principles.
Okay. In times of fear or hysteria, political, racial, religious, social, and economic groups often, from the best of motives, cry for the scalps of individuals or groups because they do not like their views. Do you agree with that?
Yes.
He concludes by saying the qualities of a good prosecutor are as elusive and as impossible to define as those which mark a gentleman. And those who need to be told would not understand it anyway. A sensitiveness to fair play and sportsmanship is perhaps the best protection against the abuse of power. And the citizen's safety lies in the prosecutor who tempers zeal with human kindness, who seeks truth and not victims, who serves the law and not factional purposes, and who approaches his task with humility. Do you agree with that?
Fully.
And do you think during the pendency of your special counsel work that you tried to live up to those standards?
I do.
Was there ever a prospect after you were appointed special counsel when you thought maybe you would not bring an indictment against President Trump?
Absolutely. When I took this case, I did not know enough about the facts or the law to have a judgment about whether we should proceed in either case, both cases, or neither case. I used my time when I was appointed to get up to speed on the facts and the law. But if the facts and the law did not justify going forward in this case, I would have been perfectly comfortable in doing that, as I have throughout my career in cases involving political figures when I was in public integrity and throughout my career. So I did not have a preconceived outcome in mind when I took this job.
Was there any point where you and your prosecutors that formed your team debated not bringing charges against the president?
Of course. I mean, that is the process of being a prosecutor. Is you are analyzing evidence, you're collecting facts, and you're debating whether it's what the facts mean, the inferences to be drawn from the facts, or debating what the law is, and whether you can prove what you think is happening here or not. And so that was a continual process to decide if, in fact, we could go forward. And that, again, just to be clear, that is a process that I have undergone in my career personally and with prosecutors I've supervised.
When was the decision made that you believed you needed to move forward with both indictments, both in Florida and DC?
Well, so the decision wasn't made at the same time. To the best of my recollection, in both cases, the final decision was shortly before we sought indictment.
Okay. In June of 2023, you had a meeting with the Attorney General to present a prosecution memo and basically asking for his blessing to bring the indictments. Is that correct?
We did have a meeting, and I think it was around that time. I didn't think about it as his blessing. I was presenting what I intended to do, and he had the ability to countermand that if he wanted to.
Okay. But certainly you couldn't bring an indictment without his authorization.
He could block me from doing that. That's correct.
Okay. And during that June 2023 meeting with the Attorney General, did you guys discuss both indictments, potential indictments, or just the Florida indictment or just the DC indictment?
If it was, I don't have a specific recollection of dates. And so you can check me on public records, but I believe by late June, the classified documents case had already been indicted.
Okay.
So again, this is my recollection, but that would have been a discussion in late June would have likely been about just the elections case.
Okay.
If it was about an indictment.
Okay. And the Attorney General in the June meeting, it's been reported that he expressed some reservations about the DC case. Is that correct?
I had several meetings with the Attorney General about both cases. And in those meetings, we regularly discussed legal issues, factual issues, things of that nature. Never in those meetings did he tell me I couldn't or shouldn't go forward or should go forward. It was more talking through with another experienced lawyer the legal issues present in the cases, as well as if I was going to go forward, how to best frame those.
Okay. Coming out of the June meeting, it's been reported that he asked you to spend some time with the Solicitor General to review the DC case. Is that correct?
Again, I don't recall specific conversations. What I can share with you is we consulted with the Solicitor General regularly during my time as special counsel. That was a choice I made. We wanted to make sure not only that we got the facts right, but that we got the law right as well. And so I would be surprised if the first time I consulted with the Solicitor General would have been in late June. That would surprise me.
Okay. But you did have a one-on-one meeting with the Solicitor General in person?
I've met the Solicitor General in person. My recollection is most often it would be members of my senior staff speaking with her staff about these legal issues. I did have conversations with her as well, but the majority of that was her staff and my staff speaking about things.
Okay.